For those of you I haven't had the chance to meet, my name is Sal Nuzzo. I'm one of the policy members at the James Madison Institute, which is a public policy research think tank in Tallahassee. I have the opportunity to work on criminal justice reform in Florida and in DC a bit. And so I'm really pleased to be able to kind of work with this great group of folks. A couple of opening thoughts, basically pearls of wisdom from my dad, who told me a couple of things. One is make sure you stand next to people who are far smarter than you, because it will eventually rub off. I'm still waiting for that, but I'm hoping that this panel helps out quite a bit. He also told me the definition of mixed emotion, and I hope no one will hold this against me. Mixed emotion, he said, was your mother-in-law going off of a cliff in your new Ferrari. And I feel that today. And the reason for that is I am a 25-year resident of Tallahassee, but I am a New York Yankee by birth and a Florida State Seminole by the grace of God. I stand here with one lifelong Boston Red Sox fan and eight, count them, 8 UF degrees on this panel with me. So, jumping right in, one of the things that Hank spoke of a couple of minutes ago was having a diverse array of opinions, and this panel really represents it. We have here to discuss sentencing reform. We have a Florida State policymaker, a judge, a prosecutor, a public defender, and a research organization member. So I am hopeful that the discussion will be robust, that the audience will become engaged. I have a few questions to hopefully kick us off, but then I want to kind of get out of the way and let the experts have at it. So first off, I will do a couple of quick introductions and get the party started. Len Engel over here to my left, as you all met, was the Director of Policy and Campaigns at the Crime and Justice Institute and a member of the bar in Massachusetts, Connecticut, and New York. He's been working on criminal justice and correction policy for more than 25 years with a focus on recidivism and improving public safety. He began working on Florida prison and sentencing policy 2 years ago. And he's the Red Sox fan, if you haven't figured that out yet. Judge Nellie Kazaam is a double Gator. She graduated with honors from the UF College of Law and then clerked at the 2nd District Court of Appeals. She's been in private practice, a shareholder in 2 firms, and appointed in 1994 to Circuit Court Judge in the 6th Judicial Circuit. She was then, in 2008, appointed to the 2nd District Court of Appeals. She's a member of the American Board of Trial Advocates, was a Flabada Jurist of the Year Award in 2002, and she's actually serving as their president in 2020. And I would like to remind Judge Kazaam it has been exactly 2,153 days since the University of Florida beat Florida State in football. Attorney Bill Cervone is the elected state attorney for Florida's 8th Circuit since 2000. And has served as a prosecutor for 40 years. He's a native of Tampa, holds both his bachelor's and law degrees from the University of Florida. He was hired as an assistant state attorney at the time by 8th Circuit State Attorney Gene Whitworth. In '85, he was recognized as Florida's Outstanding Prosecutor of the Year by the Florida Prosecuting Attorneys Association. And I would like to remind Mr. Cervone, it's been exactly 1,783 days since UF beat FSU in basketball. Stacey Scott, also a double Gator, was appointed public defender of the 8th Judicial Circuit in 2010. In 2012, Stacy was elected to the office by the people of the 8th Judicial Circuit and subsequently reelected in 2016. Prior to becoming the elected public defender, she served as the assistant public defender for over 10 years. She's been an assistant state attorney, working on both sides, and worked in the private sector as a criminal defense attorney. And I would remind her it's been exactly 1,503 days since the Gators beat the Seminoles in soccer. Last but not least, and those are all the stats I've got, Senator Rob Radley represents the North Central Floridians of District 5 in the Florida Senate. He's been a great friend and has served in the Florida legislature since 2012. He's worked as an assistant state attorney, served as a county commissioner in Clay County, on the board of trustees for St. John's River State College. He has been one of the leading voices in the legislature for examining our criminal justice policies, and is in the free time that legislators had, because we all know it's a part-time job. He's also the managing partner of a private practice law firm in Orange Park. And lastly, yes, indeed, he is also a double Gator. So we'll kick this off with a very broad-based question. And what I'm going to do is ask each of the panelists to kind of either from your chair or come and stand up, give a few minutes to opine on our sentencing policies in general. So Florida currently has a system of mandatory minimum sentences for a variety of crimes. We've made some changes over the years, but along with a requirement, as you all know, that inmates serve 85% of their sentence prior to being considered for release. From your perspective and in your role in this process, what works well in the system? What works poorly? What would you like to see changed? And what would you propose as an alternative? And just by sheer chance, we're going to go down this way and then I'll mix it up. But Stacy.
Well, thank you for having me here. Florida's criminal punishment code that's currently in place since 1998 has never really fully been examined and studied to see the impact on sentences and the lengths of sentences and the impact that it's had in different communities in our state. The stated purpose of our sentencing code is to make the best use of prisons so that violent offenders are appropriately punished, to ensure that the penalty is commensurate with the severity of the offense, and that sentencing is neutral with respect to race, gender, and socioeconomic status. However, objective data shows that this is not being complied with 63% of new admissions in 2016 for nonviolent offenses, with half of new admissions in 2016 with no prior violent crimes, with the increase in the length of sentence and the length of stay, and with the overrepresentation of African American inmates in our population, which are 46% of our incarcerated population in this country, while only representing 16% of the population, we know that there are problems. And there's never really been a true comprehensive study to show how our sentencing laws are being put into effect in courtrooms every day. In particular, some of our most draconian sentencing laws, like the habitual felony offender statute, habitual violent felony offender, and the PRR statute, have not been comprehensively studied since 1992. In 1992, and I'll credit Mr. Blaise Tredis, the public defender from the 18th Circuit, with this, providing me with this study, there was an empirical examination of the application of the HFO statute that was commissioned by the Joint Legislative Management Committee of the Florida Legislature. And the findings of that study are alarming, and they've never been acted upon. It found that the HFO statute was not effectively targeting against the very worst offenders. It found that the circuit of prosecution made a significant difference in the probability of habitualization and therefore in the length of the prison sentence. So there was no statewide system of reasonably uniform sentencing. In effect, there were 20 different sentencing systems. And it also found that there was an unmistakable racial bias against African American folks who were sentenced. Across the state, an African American was 2 to 4 times more likely to be habitualized and therefore receive a longer sentence than a comparative white person being sentenced by the court. The study made policy recommendations that were not followed through with. So we need a study of our criminal punishment code to see what it's doing, who it's doing it to, and what the effect is. Additionally, the current criminal punishment code, which was significantly altered from the sentencing guidelines that were in place previously, has never really been looked at. And one of my recommendations is that we would return to a system akin to 1994 or 1995 sentencing guidelines, which provided for a range of possible prison sentences. Because under the current code, as you all know, the possible range is non-state prison all the way up to the statutory maximum. So at least for a significant number of nonviolent offenses, we should seriously look at returning to those types of guidelines that provide a minimum sentence and a maximum so that there'll be more consistency across the state. One of my other recommendations, and stop me if I run out of time, is that we fully reinstate substance abuse, addiction, or abuse as a basis for a downward departure. That provision was specifically removed by the legislature some years ago so that a judge cannot go below a minimum mandatory anymore based on someone's addiction to substances. There's a small exception that provides that if people score less than 60 points and can get into post-conviction drug court, that a judge can deviate downward, but those courts aren't widely available and bed space is limited. So that would be an excellent way to provide our judges with more discretion to deal with the opioid crisis, to deal with the addiction crisis in our communities without overly incarcerating people who are addicted to drugs. And the final thing that, aside from all the things you've already heard about increasing the felony theft thresholds and drug trafficking thresholds, is an important issue. Right now, a person can get a minimum mandatory sentence for 14 pills, a 3-year minimum mandatory. A typical user uses about 10 to 15 pills per day. So mere possession of the drug that someone's addicted to can get them this minimum mandatory, and a week's supply, which is about 50 pills, can get someone 15 years. So those thresholds need to be raised, and judges need to have individualized discretion to go below them, to go below the minimum mandatories that are in existence. Thank you.
Thank you, Judge. Thank you, Stacey. Judge Kazaam, your thoughts?
Well, good afternoon, and thank you for allowing me to be here. When Hank first approached me to be on this panel, and I said, you really want an appellate court judge? It's been 10 years since I served in the circuit court. For 14 years, I served as a circuit judge in Pinellas County. But Hank insisted, no, we want you to be on this panel. So in preparation for today, I decided to call our state attorney, Bernie McCabe, as well as I spoke to 4 circuit court judges that were my contemporaries that I have a lot of respect for and that are very respected in Pinellas County. So my observation that I'm going to share with you today is a combination of my observations as well as theirs. And there's 2 things that I'm just going to focus on. One is those mandatory minimum sentences. One of the judges, to quote him, I hate them. I hate them. Why does he hate them? He has no discretion. And I'm going to give you a couple of examples that we have judges have seen, we wrestle with, and we have no discretion to do otherwise. One of the examples, actually, I recall this vividly when I was still on the circuit court bench. I was sitting in the career criminal division, and it was not my case. It was one of the judges' case that I talked to. He had a case involving the following: 3 college students, great college students, great kids, happened to be home for spring break. What did they do? They did something stupid. They got drunk, and one of them had a great idea. Wouldn't it be wonderful for you to get your loaded gun and go back to the backyard and see if we could do target practice at the neighbor's shed that's locked? So you could imagine, it is shooting a weapon, and it is it's a locked shed. And the charges that they were facing, they were looking at a mandatory minimum sentence. We're talking about 10, 20 life. The judge is like powerless because that was in front of him. He has no discretion to do otherwise. That's problematic. Another example that was given to me is the ones that you all have seen, is grandma or the young mother who gets in an accident, then suddenly gets prescribed certain prescription medication, gets hooked on those prescription medication, and in order for them to relieve some of the pain that they're incurring, they end up getting caught. They end up at that point looking at trafficking amount and then looking at mandatory prison. So these are harsh sentences. So you start thinking, well, what is the solution? What can we do? Legislatures, bless their hearts, they work hard, but they don't want to be seen as soft on crime. State attorneys don't want to come out across that they're not doing their duty by not charging or bringing in charges where otherwise they need to do. So here's a compromise of some sorts that perhaps that we could accomplish for discussion purposes. Right now, we do have the judges have the discretion for some of the guideline sentence to depart. And to state the reasons, I know Stacy mentioned one of the things that you'd want to include, but at least they're able to go through and check mark perhaps a departure sentence. None of that is available for the mandatory minimum sentence. So perhaps have that put in place, very similar to a guideline departure, and then hold these judges accountable. Let them state the reason for exceptional circumstances. Let them explain why. And like the others, they could be appealed to the appellate court. So perhaps that could take into account some of the harsh sentences that are imposed, the mother, the grandmother, or the kids, that perhaps if the judge would have that discretion, set forth that under this exceptional circumstance, this would be more appropriate. That's one thing of the mandatory minimum. The other one, Sal, that they've mentioned to me is this mandatory adjudication. Right now, the way things are, that depending on the charged crime, they have no discretion other than to adjudicate someone once they're found, guilty of it. The thing that concerns them, that they see people with no prior record. And I think Len had mentioned that in some of the stats, where 30% of our prison population are there with no prior record. Perhaps this is something else that could be given discretion, to the court. And the other example, and the final example that I will give you all, is one of the judges had a case just this past week. Two neighbors, they happen to both be elderly. One of them is 68, the other one's 72. It's in our books that if you're dealing with an aggravated battery of an elderly person, it's enhanced. So these are neighbors. One neighbor was 72, does not care for the other neighbor. So she's been going to his lawn and just doing all sorts of things. The 68-year-old neighbor finally got fed up. What did he do? He shouldn't have done it. He grabbed a pipe and bonked her on her head. Well, thank God, whatever happened, she was not that seriously hurt, but it was charged. He's now looking with no prior record. He's looking at a mandatory sentence. I don't think that that's what the criminal punishment code contemplated. So perhaps maybe a happy medium and a compromise. And I look forward to the discussion that perhaps maybe a little bit more discretion given to the courts to handle those type of cases. Thank you.
Thank you, Judge. Senator Radley, you've been in the legislature for a number of years now. Tell us a little bit about your perspective on how the process has helped in driving the discussion, where you see the bright spots, and where you see there's still room and desire for change.
Sure. I've been in the legislature. I'll be going on my 7th year, and I'm going to term limit out after my 8th year. And I do think there is a perception that my colleagues are concerned about being seen. You mentioned soft on crime, and I think that may be a bit overstated in the sense that what I've seen in my time there is not necessarily that there are folks who are concerned about that, but instead. And I'll give you a couple of examples of policies that we've done, which if one was concerned about being perceived as soft on crime, you would not vote for. I think it's more driven by the fact, and I was privileged to serve as the appropriations chair in the Senate this past year. Just to give you a sense, we heard a lot of numbers of billions in impact on the budget. I went ahead and pulled before I came here what exactly the percentage of our budget is dealing with corrections. It's 2.5 billion. Our total budget is $87 billion. So we're talking about something that's 2.5% of our budget. So while these are serious dollars, part of the reason why there isn't a lot of change, major policy change, is that it doesn't really move the needle from a budgetary standpoint and a taxpayer standpoint, whatever decisions we make. So therefore, when we focus on what to do in this space, it's not driven by the fact that, oh my gosh, we're going to have to raise taxes or we're going to have to do something if we don't act. It's just that there isn't a budgetary urgency that perhaps when you hear numbers, you think that there is. I will tell you what motivates many of us is not saving money. And when I talk to my constituents, they're not concerned about spending money to keep themselves safe. What they're concerned about is keeping themselves safe. So the answers are, what is the appropriate public policy to make us the safest, number one. And I would argue to you that much like we've heard before, this idea that we incarcerate too many people in the state of Florida, I agree with. And I think that it's not a new discussion in Tallahassee, because many of us have been convinced that in certain situations, when you incarcerate someone, you don't make things better, you just make better criminals in some case, and you make us less safe. And number two, I think our DOC, our Department of Corrections, has some operational issues that have been discussed before, where I don't think the system, from an operational standpoint, not necessarily how many dollars we spend, okay, but literally how they're able to function being the size they are and handling 100,000 people. I think that I've been convinced over the years that the system cannot properly handle 100,000 people. And so we either need to have less people incarcerated in the Department of Corrections, or we need to fundamentally change how we handle them. But the status quo, I think, is not something that's acceptable. So I want to kind of shift the discussion away a little bit from saving money, not that that was where it was, or even this idea about whether you're afraid of being soft on crime or not soft on crime. I think it's more, in my mind and in many of my colleagues' minds, an issue of the DOC not being able to handle what they have right now, and what can we do to make us safer. All right, and so certainly some of the options I think that have been in front of us over the years, some have been adopted and some of them haven't, particularly in the juvenile justice space. I know that I haven't heard any talk of that since I've been here, and I just got here earlier, but I think that when you look at where the juvenile justice system was 6 years ago compared to where it is now, there's been a complete mindset change in focusing not so much on keeping people behind. We don't incarcerate them, I guess. We put them in residential. But getting away from deterrence and surveillance and control models and more towards the getting on the front end services and plowing money into services on the front end. And I think if you look at the decisions that have been made, and I think we have to be honest about what we've done and where we've fallen short, we have demonstrated a focus on putting money on the front end. This past year, I pulled some numbers. We had a 22% increase in our prevention, things like PACE Center for Girls, AI, the kids, the AMI kids for boys, and we have really made sure, not only from a budgetary but a policy standpoint, that the system is designed so that they have the money to view the child when they've been identified as a potential offender or an offender, do a complete assessment of the child, and then decide what is the appropriate response and the data-driven response to where the child is in his or her situation. So I think we're doing the right things in the juvenile space. The adult space, it's been much more modest. And when I say that, I'll give you two examples. Two bills I've sponsored. One is taking aggravated assault out of 1020 life, so that the factual scenario you just described, that sounded like an aggravated assault to me. That used to be a mandatory 1020 life. It isn't anymore in the state of Florida. And because, in many of our viewpoints, from many of the legislators' viewpoints, if the government has evidence that someone took a gun and tried to kill somebody, then and they were not successful, that's an attempted murder. Okay, that's not an aggravated assault. And so being able to leverage aggravated assault to get a higher sentence is probably not an appropriate lever to have in the criminal justice system. But again, that's a modest change. And I acknowledge that, but in the Senate, it passed unanimously. And I think in the House, the numbers were similar. Maybe one or two people voted. And then and Ms. Scott mentioned the fact that a user can have a certain number of pills and then be subjected to 3-year minimum mandatory trafficking charges. I agree. We had a bill that passed unanimously in the Senate that raised that threshold. It used to be 7 pills, but and I don't think it raised it enough, but it raised the threshold. Taking into account the arguments you were making that isn't a trafficker, that is a user. I think so there are some, and there's been reforms related to the prisons that we haven't gone far enough on. And I don't say that to say that we're done in Tallahassee. We're not. We're just starting to make a lot of major changes in this area from a policy standpoint. I bring this up to say that this is not a new discussion. This isn't the beginning of this discussion. This is something that has been discussed for many, many years in Tallahassee. I recognize many of the folks out here who've attended the committees before, but perhaps some in the bar who are just becoming interested in this. And when I talk to some of my colleagues who are lawyers, and our firm actually practices criminal defense, so I'm kind of familiar with how it impacts individuals in their daily lives, our system. I think there is somewhat of a disconnect between what people perceive as happening in Tallahassee and the actual level of discussion. There's a lot of discussion. A lot of times it doesn't make it across the finish line, or it's more modest than one would like, really for the reasons I described, because it, at the end of the day, is not a huge driver of the budget in the state of Florida, number one. And number two, frankly, a lot of my colleagues don't have the professional background that many, that I do, and some of us who are interested in it. And so they're focused on other things that are the economy, creating jobs, insurance, whatever it may be, transportation, healthcare, all of which are very critical to people's daily lives. So I think it's important in these to look at the fact that when we're over there for 60 days, this is important, but it is not central. And it's important. It's been discussed, but it's not central to the state government dialogue.
Thank you, Senator. Bill?
Well, let me begin by acknowledging the obvious. I am the voice of the loyal opposition in a lot of ways to some of the things that are being discussed here. And I will start by saying that as a part of that, it is only 39 days until the Gators beat FSU for the next time in football. I have been around this system long enough to have seen the wheel go full circle a couple of times in a lot of the things that we do. I have a close friend, now retired from the circuit bench in Gainesville, who by all accounts would have been considered one of the more liberal judges in terms of philosophy and background before he took the bench, whose personal theory was, with the exception of obvious things like murder, 1 strike, nothing happens to you. 2 strikes, nothing happens to you. We're just keeping a record. 3 strikes, you're gone, and I don't want to see you again. Now, he said that to be hyperbolic in what he was saying, but there is some merit to that kind of consideration. My own experience in the criminal justice system has been, and from very early when I was prosecuting in juvenile court, that some people can and will commit disproportionately large numbers of crimes. If I could, for example, have taken a couple of families in juvenile court back in the 70s when I was there and removed every child at birth, I could have impacted the crime rate in Gainesville by those kids having a fighting chance in life as opposed to being raised to be criminals, which they successfully became, and where they became very prolific offenders. This may sound simplistic, and I suspect Len will tell me it very much is simplistic, but I look at the charts and I see incarceration rates going up and crime rates going down, and they look like a mirror image of one to the other to me. To me, you cannot escape the conclusion that incarcerating the right people, even if it is for long periods of time, makes all of the rest of us safer. And that is so whether it is safe from the most violent among us or safe from those who will constantly prey upon our property, burglary, theft, whatever it happens to be. To me, it's kind of like this. If you have a chronic health issue, and I would liken criminal conduct, which has always been and will always be with us, if you have a chronic health issue and you get it under control with some sort of medication, and the medication in this sense may well be some of the sentencing options that we have available to us from legislatures past, stop taking the medication and that chronic health issue that you had under control will come back. To me, we must be cautious in what we try to do away with, and we must avoid thinking we've got this problem solved, and if we just are a little bit more gentle, if we just do away with this possibility or that possibility, it won't come back. Ladies and gentlemen, I believe it will come back. I would say also that stats do not tell the whole story. When I'm in Tallahassee in front of Senator Radley's committees or elsewhere, I often hear horror stories of particular cases. And I readily acknowledge that there are cases that on their face, somewhere in the state, sound like some sort of injustice. I will tell you this, though, there usually is far more to that story, just like there is usually far more to the individual who ends up incarcerated for something that seems rather innocuous if you just look at the face of it. It may be that the facial crime that got somebody sent to prison was a reduced charge or a negotiated plea under which multiple other crimes were gotten rid of, and there was no attention to that. It may be that the offender is somebody who has gone before a judge so many times that what do you realistically expect a judge to say sitting in front of a courtroom of other people watching his or her behavior? If a judge is constantly on the bench saying, I'm putting you on probation, probation means something, don't violate probation or I will have to send you to prison, and then repeatedly in front of other offenders says, well, I didn't really mean it, I'm not going to do it, what kind of message does that send? I think all jurists must feel on the bench that there comes a point in time where their bluff cannot be called, and even if they don't want to, they must impose a sentence on somebody because that person's behavior has well and truly earned it. I disagree to some extent that this is not a monetary conversation. And I've heard many people in Tallahassee, not Senator Radley, but others, who have said almost in so many words, we can't afford our prison system. That's probably so. We can't afford it as it is now. That begs the question, though, of what we are going to do to try to afford it and what we can do to try to better use the resources that we have. Prosecutors are not anti-reform. We are not knee-jerk, lock them up and throw away the key people. We do believe that the resources the legislature gave us in terms of things like 1020 life back in the 90s when crime was truly rampant have made a difference in allowing us to incarcerate the right people. We do believe that homicide offenders, for example, when they receive a life sentence, may well have committed an offense that society simply cannot ever tolerate sending the message, you'll get out someday. It may just be that there are some things that are that serious to our society and that we mean it. And I say that in response to some of the things Len will talk about and has already talked about with, well, maybe we can cap ages at which we can just let you out. Ladies and gentlemen, I've been to parole hearings on folks who have now reached into their 60s after having served maybe the mandatory 25% or 25 years on old sentences. What they did simply means to me and to many of our society who want to feel safe that they should forfeit life in a free society. Perhaps what I'm talking about is incapacitation of some individuals who are the worst among us as much as recidivism, and maybe that's a concept. Now, I mentioned that prosecutors are not anti-reform, so let me talk to you about some of the things that we believe need to be addressed and that we think can be addressed. And I would caveat this by saying I do not speak here on behalf of Florida's 20 state attorneys or the Florida Prosecuting Attorneys Association, although my views may be reflective of some, they are not reflective of all, and we have not taken formal positions on things that the legislature has not even proposed for next year. But I can say this. To me, maybe the abolition of parole was one of the dumbest things we ever did. Maybe we need to go back and look at that as something that might serve some valuable re-entry posture towards the large majority of prisoners who we know will at some day get out. Perhaps the way that the current secretary is approaching re-entry programs is where a lot of money needs to be focused. And I do not know who the Secretary of the Department of Corrections will be this time next year. I do know that I personally hope that whoever it is will continue to focus on reentry efforts. Things like grand theft denomination, the dollar denomination. Last year when that was debated for us, prosecutors were all for it. Now we may disagree that $1,500 is the appropriate level or $1,200 or whatever it is, but we understand that $300 is decades old in trying to determine that amount. To me, $1,500 doesn't sound very penny, especially if it's my $1,500, but there is some sort of amount in there that probably is something that we need to do. Those are simple fixes, however, that are not going to impact the prison population very much. Something that I am much more concerned about, and this is again me speaking personally, is this. There are long-term ramifications to many people that far outlive whatever the offense they committed were. I'm talking about things as simple as a felony adjudication, a permanent DUI license suspension for somebody who maybe got that 20 or 30 years ago and has decades worth of demonstrable rehabilitation. We have a kind of knee-jerk, halfway Romeo and Juliet kind of solution in dealing with some sex offenders. Maybe what we need to do to help the people who the criminal justice system has dealt with decades ago is look at where they are now and whether there should be an escape valve for what we did rightfully so back when they committed it. Maybe there needs to be some mechanism to allow them to say, this is where I am today, not where I was when I was a 20-year-old kid who got adjudicated on a bad day by the wrong judge in the wrong courtroom. Those kinds of reforms, I think, are much more meaningful in terms of the average Joe on the street. I'll give you real examples with long-term DUI folks. They deserved that permanent license suspension whenever they got it. Maybe decades later, when you can show that they are no longer a drinker, they deserve the opportunity to be able to get a job that they can actually drive to. Those are the kinds of things where I think reform can impact our ordinary citizens, the people on the streets, in other more productive ways.
Thank you very much. A lot of good information. Len, you want to take it through?
I think we're done. I think he started that.
Well, my colleagues didn't walk out.
And Buddy didn't correct you from the audience. So.
That's with a text he just said.
Yeah.
Only kidding. I don't have a whole lot more to add. First, I don't have the practical experience as my colleagues on the panel in understanding the intricacies of Florida's system. Having looked at the data, as Bill mentioned, it is numbers. It doesn't tell the human story behind every piece of that data. There is a person who got sentenced, there is a victim, or there is a consequence or a cost to society for the criminal behavior. But what I will say is that we're at this point across the country because for years we thought incarceration was an appropriate and often a necessary response to criminal behavior. We thought that incarceration would cure somebody of their criminal tendencies. We thought that time out, as it hasn't worked for my children now that I think about it, but a time out will be of a benefit to the person and therefore to the public because it'll improve public safety. So we're talking about laws that were adopted a generation or longer ago based on a different set of research findings, understanding of what actually is appropriate to respond to criminal behavior. In the past 20 years, we have a wealth of information from researchers across the country across the globe that tells a very different story about the use of incarceration, the causes of criminal behavior, the causes of habitual, chronic criminal behavior. We understand that very often criminal behavior is caused by not only bad decision making, but a lifetime of bad guides. You learn behavior from those you're around, and when you grow up in certain environments and your friends are antisocial and they've made bad decisions, you're more likely to make bad decisions. We know that behavior is largely what is causing criminal behavior. We know that one of the primary characteristics of chronic crime is what we call behavioral characteristics. That antisocial tendencies, peers, decisions made in haste, but without a sense of the consequences. People act impulsively. This is the result of years of research that we now have that our predecessors in state houses across the country did not have 20, 30 years ago, 40 years ago, when many of these laws were made. With that information, we can now ask different questions. We can ask, what is the cause of this person's, with the defendant's criminal behavior, and do we have an appropriate response for that? Is it serious enough that it warrants incarceration? Is it serious enough that it warrants a very long period of incarceration? Can incarceration turn this person into, a tax-paying, stable member of the community when they return? Are the characteristics of what's driving this criminal behavior things that can be addressed in the community through better supervision practices, through the availability of behavioral health responses, with collaborations with local agencies that address the lack of employment skills, anger management issues, things like that? We have that information now, and those are being used. I think they're being used to great effect in spots around Florida, around the country. The Secretary has made significant progress in developing a reentry program in prison that helps pave the way for folks leaving the facility. But because of that, people shouldn't be sent to prison because that's the place to get treatment. The research shows us very clearly that people are better, they react far better to treatment and supervision in the community than to treatment in a custodial environment, in a prison. We know that. So with that information, can we make better decisions at sentencing? Can we make better decisions for supervision? Can we make better decisions at charge decisions? Part of that, though, is can we make better laws that allow for that discretion to be used? I think the conversations we're having today, the conversations that occurred in Tallahassee last session, I think are exactly what should be happening. Right now, states across the country are grappling with this influx of research and data. They're asking questions that they've never asked before on the use of incarceration, on prison budgets, on the availability of treatment in the community. All that is a good thing. All that means that there are a lot more well-educated lawmakers and policymakers, agency heads, and criminal justice practitioners in the community. And I think the opportunity now is to put those heads together and to take the information that we have, the research, the data, and the experiences of folks on the line, and start to make some changes.
Thank you very much. Bill, there were two things that you pointed to, and Len, you alluded to in your discussion this afternoon before here, and that was, you called it the abolition of parole, the 85% rule. So I want to come over to this side, and if you could give us some thoughts from your perspective on, is that a viable policy track to take? Is it practical within the context of what the legislature does and is considering, and what would potentially be the ramifications for that? So we can start over on that end. Stacy.
Well, from my perspective, it is possible because anything's possible when good policymakers come together and do things that make sense. Focusing the 85% rule on the most serious crimes and the most violent crimes is what makes sense. Because if our prison resources are limited, we should focus using the toughest sentences on the most serious offenses. And we should consider relaxing the 85% rule for property crimes and other nonviolent crimes, and try to incentivize folks who are incarcerated to participate in programs and to earn gain time so that they are encouraged to come back to their communities more prepared to become a member of the community. Because as we've noted, most people who are incarcerated are coming home. And when they come home, they are facing enormous barriers. A felony conviction alone is an embedded consequence that follows someone for life. And when someone comes out of prison, even if while they were in prison, they had an epiphany, they bettered themselves, they realized their mistakes, and they're ready to start anew, when they come back to community, they face barriers. They can't get jobs. They're back in the same neighborhood. Oftentimes they can't reside with their relatives who may have places in public housing because of their record. And there's just a barrier upon barrier upon barrier that we need to deal with. But I think focusing our resources on the most violent offenders and relaxing it for, let's say, levels 1 through 5 offenses in the punishment code that are nonviolent or something like that to make more sense so that not everybody is treated as though they were a serious violent offender.
Judge.
Actually, I agree with Stacy.
Senator?
The folks at CGI, and you heard their presentation today, were invited by the legislature a couple of years ago. We were embedded in the budget to specifically bring them in and give us the data that you were privy to. And I think that it illuminates a couple of things. One is that back to the premise of what can we do to make people safer? If we are incarcerating, putting aside the cost for the purposes of this discussion, if we are incarcerating people and that in fact is making society more dangerous, then that is not a sensible policy. So that means that we, and this is where I think the data and the politics kind of marry a little bit, in the sense that I think when it comes to violent criminals, people who have done violent acts against their fellow man, you have not only the idea that we need to protect people's lives by removing them from society, but you also have victims who expect that they live in a society where justice is served, and expect there to be an appropriate response to what has happened to them. But take those violent individuals, and they are going to be dealt with, I think, under our laws harshly. And I don't see a lot of appetite for changing that. But where I do see an appetite for change, and is to continue some of the things that we have done already, but put more resources and put more policy behind it, and that is those nonviolent crimes, particularly drug crimes. Those are the individuals that I think concern me, that perhaps they would not be leading a life of crime, but for the intervention of sitting in jail and being exposed to a lot of people who that's all they know. And that is, so they are now in an environment where they're not getting better, they're actually getting worse, and therefore endangering themselves, their families, and others. And the question is, what do you do about those individuals from a policy and a budgetary standpoint? I think specialty courts, drug courts, and mental health courts are important tools to empower the judge, first and foremost, and then the PDs and the SAs that are there to evaluate cases on an individual basis. Oftentimes there is not a victim, so to speak, who is in the hospital or But this, you were talking about someone who has hurt themselves and obviously hurt their family by making these decisions. But there is not a family that is expecting the justice system to make it right, sitting in the courtroom, which is important, by the way. I'm not discounting that. I think that's an incredibly important part of our system and should be honored. But those situations, those nonviolent situations, I think are places where we need to look to get rid of minimum mandatories, quite frankly, and increase the already more and more robust investments in specialty courts to identify someone who has a mental problem or a substance abuse problem, and then have in the courtroom not just a judge and a state attorney and a defense attorney who has identified this, but also the providers in the given community are there. And then you marry the person in front of you with the appropriate treatment protocols. The same philosophy that we're doing in the juvenile justice system, which is, these are 13, 14, 15-year-olds whose brains are still forming. And we have a society, I think, rightfully decided that they are not going to be treated as adults because we're a civilized group of folks who've made that decision collectively. And so our goal needs to be, let's marry what the needs are of the person with something to make them better and to improve their lot in life and improve their family's lot in life. So I think where the discussion probably needs to be focused from a practical standpoint, and I think the data supports this, is what do we do with nonviolent crimes going forward? Because when you start talking about violent crimes, my area of the state, Jacksonville, will tell you. I don't represent Jacksonville, it's in my neighborhood. The minute everything starts the discussion is about violence and gun crime and murders, then that is beyond just the horrible impacts on the people who were the victims in those cases and the families that were the victims. That then affects your economy, that then affects everything else in the world. And you cannot send a message to the world that this isn't something we're not going to take seriously going forward. And I just don't. So I think that the focus is best on the nonviolent.
Excellent. Yes, go for it.
I'd like to endorse something that the senator is actually saying. I can tell you demonstrably, I can tell you from data, and I can tell you just intuitively from being in my courtrooms, most of those defendants have mental health problems or substance abuse problems. I can also tell you that in my circuit, which has Alachua County surrounded by 5 very rural counties, I have no means to provide the kinds of things like mental health court, drug court, vet court, all those good programs that we have in Alachua and that I know metropolitan areas have. You want to reform? I would reform some money to us to have those programs in those counties. System-wide, courts, PDs, us.
One other topic that I'd like to touch on and then open it up to the audience is something you referenced regarding reentry, and Stacy, you touched on it as well. And that's this theme that we have a term at JMI, we call it collateral consequences, and that is folks come out of prison, they have a felony conviction. In many cases, they are impacted in their ability to gain employment, hold a job, get a driver's license or have their driver's license reinstated. It impacts their ability to become a productive member of society. Once again, are there programs, are there policies in place, and are there data indicating where the state is either doing something really well? I mean, we've talked about DOC. Are there things we could be doing a little bit better in terms of trying to get folks who, you're absolutely right, I think the figure is something like 90 or more than 90% of inmates in Florida will be released at some point. What can we be doing or what are we doing really well to get them on their feet?
Well, in our circuit, and Bill can correct me if I'm wrong, I don't know that we're doing a lot very well. I think people come back to the community and they face these barriers, and it's extremely difficult for them to overcome. Certain things like ban the box ideas where someone doesn't have to disclose their prior record on an initial application, so they at least get their foot in the door and get seen as a person and not as the crime they committed. And then if somebody wants to hire them, then they can disclose their record and someone can judge them on their merits and not on their record, their past criminal record. Things like that are really helpful, but there's got to be other kinds of support, outpatient resources for substance abuse, outpatient resources for mental health treatment. Housing issues are huge, and I know this is true across the state, but in Alachua County, there is an affordable housing crisis in our county, and it's very difficult for low-income people to find affordable, safe housing. And when you add on top of that the restrictions that are in some of the public assistance housing about people living there with criminal records, it becomes even worse. The economic disparity just in general in our county is huge. The median income for non-Hispanic white people is $51,000 a year. For African Americans, it's $26,000. And so these kinds of barriers that were already there before a criminal record are still there, and even worse when people come back. So there's a movement in our area to try to form a reentry coalition to try to work with these things. But I think this is an area where Florida is in desperate need of good ideas and better programs.
Nope. Over. Someone.
Real quickly,
Here's-
absent the statistically unusual situation of a trailing probation, which a lot of defendants do not want because they don't want to do the paper, I got nothing left after they come out of prison. I have no jurisdiction. The court has no jurisdiction. Stacy has no involvement.
Okay, Judge?
Here's perhaps maybe a suggestion. I know it has been done in the past because I know several business people in the community. Perhaps maybe give them incentive for tax credits to hire nonviolent offenders that have been released, especially in the service industry. There's always room to hire folks. Give them a little incentive, give them some tax credit, and perhaps that would help. The other thing too, which perhaps I could suggest, which it used to be in the past, but I'm not that familiar with what programs are still available in state prison. It used to be they would have programs for folks that have not received their GED to get GED while they're being, spending time. That is valuable because this is what's sad, where some things never change. It's been 10 years since I've been on the circuit bench. Well, that has not changed, where there's a lot of folks still do not have their GED. And I remember way back when there was a group of us judges that we had a prior sheriff, we had a prior folks where we all got together and we thought, okay, we realized when we were taking people's pleas that a lot of them have not gone beyond the 4th or 5th grade. So we decided, well, if we, while they're spending time in the Pinellas County Jail, basically we'll tell them, if you get your GED, we will knock off 30 days off your sentence. Doesn't seem much, but it gives them the incentive. And the way that it was set up, it was great, because at that point you tell them, all you need to do, you get your GED, we'll get the certificate from the jail, they'll come to us, we will grant it. These folks were so eager, you'd be amazed how many of them went through to get their GED, which I think in the long run, those folks will have their GED, they'll be able to go in the workplace again to try to reduce some things. So again, it's thinking broadly, it's thinking practically, and perhaps in the long run, will save a great deal of money rather than having them spend time in prison.
Now, as appropriations chair, you have some involvement in tax incentives. Any thoughts there?
I'm not sure about the tax incentives, but what I will tell you is that, and I'm not dismissing the idea, I'm just, someone posed the question, what do we do? What is the model? The model is Kevin Gay, Operation New Hope in Jacksonville. Kevin Gay's here. He has a nationally recognized program. The judges, the state attorney has interfaced with them. He keeps data. So when people get out and they go back to their community, he identifies them. He has employers who realize that these individuals are often willing to do things that other folks aren't willing to do. And he contacts them before they get out so that they take advantage of the resources that are available in our prison system. If someone wants to get their GED, or engage in literacy or online career education, which we've increased over the years a lot. And we opened 3 reentry centers in the last several years as well. I don't say that to say we're doing it all right or that we can't do better. What I'm saying is that these are all ideas that have been presented to the legislature that your taxpayers' dollars fund right now. And there are models that work. The problem is that in some communities, you don't have a Kevin Gay in Operation New Hope. You need to have someone who cares deeply about and has a passion for it in order to make that a reality in other areas of the state. There's Ready for Work in Tampa, I believe, is another one, and some others. And I think they do a good job, but there's others that don't do as not a good of a job. Other of these things. So on the reentry front, absolutely. When someone's over 90% actually are going to leave. Very rarely does someone die in prison or have a life sentence. It's a small percentage of them that are. So it's dumb public policy not to have them have skills for when they come out, because they're coming out. That's just a fact of life, and not having them being able to read or have a skill or be educated is bad public policy. Do we do it enough? Do we need to do it more? Those are all things that are worthy of discussion and debate. But know that there are models that exist out there. And if you are passionate about this, call Kevin Gay, who is here, about reentry. He has figured out all the various complex factors that go into this small cohort of people when they go back into society. Now, on the front end, before they're leaving, we were talking about specialty courts and identifying substance abuse and mental health. Those are the 2 things that an individual that's just not a bad person, they're hooked on drugs or alcohol, or they're mentally ill. All right. So as a just society, we want to take that into account in our sentencing and how we handle them, because they're not inherently evil. They've got a sickness, whatever it may be. We're focusing on the. I think there's a couple things. One, the sentencing reform we talked to give judges more flexibility in those situations. And number 2, the specialty courts. And to Mr. Cervone's point, there is a disparity between Alachua County and Clay County. I used to represent Alachua and Clay. We started Veterans Court in both Clay and Alachua County. But there's other counties that just don't have the infrastructure to be able to handle that. That is a problem in rural counties. There is a rural disparity. That's a problem in every. You're seeing that problem play out right now with Hurricane Michael, and the lack of news coverage or attention to what is a absolute disaster, the likes of which our state hasn't seen, but no one's there, relatively, compared to more of the urban areas. And so you see that play out in some, when people are scattered and not in urban areas, getting them services is always a challenge, but it's a challenge that we should meet going forward, I think.
Great. Well, I've used up all of the moderator discretion questions, so we're going to open it up for the final 30 minutes of the panel, and I'm imagining there might be a couple. We're going to go there, then one, and then one back. So, yes, sir.
Thank you. In 1995, after 12 years of the sentencing guidelines, the Florida Department of Corrections did a study of the sentencing guidelines and found that race played no role in sentencing in Florida. In 2016, after many years of the criminal punishment code, the Sarasota Herald Tribune did an extensive study of sentencing in Florida called Bias on the Bench, which won Florida Bar's highest journalist award, and found significant and severe racial discrimination disparity in sentencing throughout almost all of Florida. It varied from parts of Florida, but in the overall sum could be said that on average, blacks are sentenced to 60% more prison time than whites when they're charged with the same crime with the same background as shown by the criminal punishment code score sheet. So knowing this, that there is objective proof of significant racial disparity in sentencing in Florida, I'd like to ask the panel if you believe that racial disparity in sentencing in Florida, should that be a consideration for the legislature to consider in looking at the criminal punishment code to change so that that disparity might be eliminated?
Anyone want to take a
Go
stab?
first.
Yes. That's
No.
it, yes.
No. Let me answer it to you this way. I have seen that study. I have had the opportunity to look at the facts in my circuit. I have tried to get the underlying data from the reporters. They refused to give it to us. I do not believe the accuracy and the insinuation of that study, period. Judge?
May I jump in? Because I know that that was the impetus behind Representative Sprouse using the Sixth Circuit as a pilot project, because that obviously generated a lot of publicity. And of course, the view was you judges, and it was geared to you judges are being either racist or you are providing different sentences if someone is African American versus someone who's Caucasian. And obviously that alarmed a lot of judges, because a lot of us don't think that we don't think that way. And so digging into deeper, as you know, a lot of the sentences that courts do, these are agreed upon disposition that the prosecutor and the defense get together to have the court just simply apply. And a lot of times the judges would accept that type of disposition. So to follow through what you said, it'll be very interesting to see the data that will come out after Representative Sprouse, this study, which the Sixth Circuit now is being a pilot to really determine, to really crunch the numbers and to really look at that to see whether that disparity, and where's that disparity, where is it coming from, and what can be done about it.
Yes, Stacy?
Well, to elaborate on my yes, I'm not endorsing the methodology of the Sarasota Times Herald data necessarily. What I'm saying is that a study is needed, and I think Representative Sprouse's data bill is a help. But we already had evidence from all the way back in 1992 when the legislature commissioned a study to look at the habitual offender statute that showed that there was significant racial disparity in when the prosecutors seek to habitualize people based on race. For example, in Fort Pierce, a black offender with a similar background to a white offender was 4.49 times more likely to be habitualized and therefore receive a longer sentence than a white offender. Whereas, in Tallahassee, it was 3.37. In my area of Gainesville, it was 1.94 more likely that a black offender would be habitualized and get a longer sentence. So we already have evidence that there could be racial disparity and it needs to be studied. I mean, in Alachua County alone, we have a disproportionate overrepresentation of black people in our jail. We have 70%, on a snapshot day in Alachua County Jail, 70% of the inmates are black. They only represent about 22%, black people only represent about 22% of our population in Alachua County. On juvenile arrests alone, even our wonderful police department and Gainesville Police Department that has made significant strides in improving arrest rates for juveniles, they've reduced the overall arrest rate, but there's still a significant minority overrepresentation in the number of arrests. So we know that's an issue. I'm not saying it's due to intentional racism or whatever, but there's something going on that deserves a really good empirical objective study, and it needs to happen now and not at some point in the future, because the study from '92 that the legislature commissioned had very specific recommendations that could be looked at to deal with the disparity in the HFO statute. None of them were ever taken up. And if anything, the statutes have become more draconian, adding more and more enhancement characteristics. So the idea that we can just say, no, we don't think there's an issue is not acceptable to me.
There was an element of your question that was policy driven, so I'd like to give Senator Radley an opportunity to talk to that.
Well, there were two major criminal justice policy initiatives this last session. One was, I believe, I did not hear the first speaker, but I believe it was discussed. It's not just going to be the Sixth Circuit, although that's the first layer of the data collection. It's going to be a statewide data collection, deep dive, really different than and deeper than anything that I'm aware of any state has ever done. And it's going to look at racial disparity issues, amongst other things, to make sure that our criminal justice system is living up to its ideals. And it's going to go farther than CJI did when we embedded that study in the budget into sort of that granular level and look at these things. I think that every public policy maker should look at anything wide-eyed and have as much data as they possibly can, and then make decisions accordingly. The other major part of the criminal justice reform that we did dealt with civil citations, which is another tool in the toolbox. And we required every single judicial circuit in the state of Florida to have a juvenile civil citation program, period. Full stop. And then also empowered adult civil citations for the entire state, and gave some guidelines for that. So these questions are important questions, and that's why we're going to not have a newspaper study, but have actual data.
Oh, sure.
Just
go for
one.
it.
Just one.
Yep.
There's not a state that's not grappling with this question. Every state is facing similar issues, and the availability of data is what's bringing this to the fore. And so states are taking this on a policy level, but it's the data analysis that's going to drive this. So no matter what the target is, the data is making this an appropriate time to examine this at a policy level.
So we're going to go there in the white top, right back there, and then over there. Yes?
Maybe not something that might reduce prison population, but certainly reentry. The suspension of driver's license for drug charges and or not paying the court costs actually directly impacts being able to go back into society when you can't get a driver's license. And that would be such a simple fix. It would really not only reduce, or assist when they're reentering, but also reduce new crime that's going to come in because they're going to try to go to work, now they can't get a driver's license. How does the panel feel about that?
If y'all don't mind, I would like to start this one because this will be an absolutely shameless plug. JMI is releasing a report exactly on that issue within the next 30 to 45 days. We've been crunching some numbers, working with some scholars. So if you're not already following me on Twitter, Sal Nuzzo, please do. Otherwise, I will leave it to the panel to talk through some of those things.
I mean, obviously, that's a huge barrier. Anyone who represents indigent clients knows that when people get their driver's license suspension for failure to pay their criminal court costs, it becomes just a cycle that's really hard to get out of. Unfortunately, the way that the court system is funded a lot, especially our clerk's offices, is based on collections from the users of the system who are the defendants. And so this is an important, but there's a cost to community that isn't being calculated in the equation. So the idea that, the clerks are gonna lose money and we need to fully fund the clerks, and then the clerks are like, no, we need the money. Well, who's really losing are the members of our community. They're losing in economic production. Their families are destabilized by lack of employment and stable housing. So what we really need to do is, Senator Bradley, is fully fund the court system with general revenue dollars instead of relying on the collections from the users of the system. And that applies to public defender budgets as well. There's my plug. That's my shameless plug.
Senator, any response?
Didn't y'all just get a raise?
We did. It was awesome. Thank you.
If you lower the prison budget, you can use some of that money to fund the clerks.
Okay, I agree wholeheartedly that we need to decouple driver's license suspensions from drug crimes, particularly marijuana and prescription and drugs. But I would be open to the whole thing for what it's worth. I don't think we should decouple it from child support. Because I will tell you that is if anybody practices family law, they'll tell you that driver's license suspension is a good hammer to make sure people pay their child support. And you talk about unintended societal costs, people not paying their child support is not something that we want to see turn into an epidemic in our society. As for court costs, I would be open to that, absolutely. It needs to be, the suspension of the driver's license needs to be related to a DUI or a driving offense. It doesn't need to be something that has it's completely unrelated to.
All right, back there and then over here.
Okay, a bunch of things from the state attorney, the public defender, the judge, and the legislator.
That was kidding.
Public defender and Judge Kazaam talked about the programs
Yeah.
in DOC. Those are prioritized for people that have about 3 years or less before they deal with. So if somebody has a sentence that's 10 years, 15 years, they're not going to get the program. So I believe Senator Radley said we shouldn't talk just about the dollars, but I'm going. Because I represented juveniles being resentenced, and some of them have long past their juvenile ages. They've been in prison.
I didn't say we shouldn't talk about the dollars. I was saying that, let me be clear, we always talk about the dollars. What I was saying is that the idea that we would be reducing the prison population to save money is not something that I hear. What I hear is that people are willing to pay for safety. We just don't need to have policies that make people less safe.
And if we do programs like Judge Khouzam and Scott said, then people are safer because we have inmates getting out of prison and they have skills and abilities. So Secretary Jones had to offset a $50 million shortfall this year, so he cut mental health substance abuse reentry programs in favor of providing for the medical needs of the elderly population, which it begins at age 50 because there is the accelerated aging that occurs in prison. So we have, Florida Tax Watch from 2014 said that a 1% reduction in the elderly population would save $67 million. That would have given us our funding for those programs that would help the younger inmates, the ones who need less time left to serve, who would get rid of the elderly inmates. And some of those are divine. I looked at many parole records. So you talk about a violent offender, they were 20, 30, 40 years ago, but maybe now you're dealing with somebody that hasn't had a disciplinary referral for 10, 20 years. You're looking at somebody that survived cancer twice in DOC. You're looking at somebody who's blind in one eye. They're not violent anymore. So they are the most costly to continue to incarcerate. They're taking a bed away from somebody who is currently violent, and they're taking the resources away from giving the programs to those that need it to avoid recidivism. So I would like to see a much better elderly release program so that juvenile offenders going in who are supposed to be rehabilitated can get those programs that we all think would be beneficial and reduce recidivism.
Anyone?
I'm totally on board with what was said about the decoupling. It's illogical to me, the fines and the driver's license, other than like the senator said for the DUI and traffic offenses.
And I'm open to talking about elderly reviews in certain circumstances. I think that the data is 37% of our elderly prison population is nonviolent. Their underlying charge was nonviolent.
Yep.
Wasn't that it?
Yeah.
Something like that. And so I think in particular in that cohort, it's something to look at. I will tell you that when you're if someone is 67 years old and they killed somebody's daughter and they got sentenced to life, then I'm not, it doesn't move a lot of people to say, to make sure so that we save, $25,000 in medical bills, that we need to let them go. I mean, that is a, that is a, those are the people that, that come and meet your elected representatives, no matter what party we are in or whatever we are, and meet your elected state attorneys and sometimes your public defenders and those folks. And they expected that justice would be served when their family member was taken away from them.
I will point out that we just indicted a 60-ish-year-old man prisoner for murdering 2 other inmates, all 3 of them having various infirmities. Like I said earlier, you got cases, but.
And we talk about individualizing things. We talk about not having a one-size-fits-all, which I think is a legitimate argument against minimum mandatories as a general rule, right? These are situations where you have to be careful.
Over here, and then we'll get over there. I apologize. I'm left leaning. Just kidding.
Guidelines Commission. And since 1983, I have to defend my child. What it protected from is the real Florida lottery, which, man, I think explains some of the numbers about why we have a static land. Every one of us knows in our jurisdiction what courtroom is the OMG courtroom, what's the O6 courtroom. We have to staff them separately because the Florida lottery is what courtroom your case gets assigned to. And that judge is going to have total license to impose that sentence. The guidelines prevent protection for appeal for departures above and protection for departures below. All that was a system that was truth in sentencing, and I don't recommend my child anymore. That's a visitation anymore.
All right, we'll go here and then over there. Yes.
Yeah, so the Nation First Drug Court was established in Miami, and the Nation First Mental Health Court was established in Broward. So I'm just wondering, as Floridians, I'm a young Floridian myself, I'm just wondering what, as a state, we need to do to get back to that. We established those things. Those are ours. And we don't even have them proliferated throughout the entire state, as the state attorney said.
Yeah, we do, though. We do.
No, I know, but we don't have the ability to fund them because of the infrastructure or the ability to.
Okay. I mean, I agree. I would agree. I don't mean to be argumentative,
No,
but
I understand.
the rural areas are a problem, and we need to address that. But in most urban areas, if you have people that will go along with it, we have people turn money away in certain jurisdictions because they didn't want to go along with drug court.
Okay.
That wasn't in their plan, battle plan.
So going off of that, what do you guys think as a state we need to do to just get back to that type of establishing? We're seeing a problem, and let's fix it as a state, and kind of as a trailblazer of change.
Well, this kind of dialogue is intended to do that, I think.
All right, back, white jacket and then behind her. Yes.
So I'm new to Florida and I come from a community corrections background, so all of this emphasis on prisons it's interesting. I come from a state that had half as many inmates, but our budget was twice as much. And I know the state of Michigan probably pays a little bit more than the state of Florida, but the fact that you had 2 times as many inmates down here with the same budget tells me you're not doing things in your institutions the right way. The programming that you have available, as Len said, is not effective in institutions. So when you have somebody with a 10-year tail and they're sitting there doing nothing for 7 years until they're eligible for programming, that's why you have inmate on inmate crime, because you've got people who have been held in these institutions for so long they can no longer function. But then when you talk about the community side of things, addressing the programs in the community, you don't have to have a set of yellow pages to refer people out for treatment here or program there. You can train your probation and parole officers to deliver programming and to have interactions with those offenders that actually lead to behavior change. Because institutions do not change behavior. Sending someone to jail or prison is likely to make them worse, as we heard. Yet we continue to think that we're going to send people to prison as
This is the preferred option, and then everything else is an alternative to incarceration. And that's one of the things that really, really gets me, is that in every other country in the industrialized, socialized world, it is not the first thing when you commit a crime that you go to prison, but it is here. Everything that we do that's called an alternative to incarceration really minimizes our opportunities to lead offenders to change behavior. And when you send them to an institution and you try to bring them home, it makes things much, much worse. If you look at the number of people in our institutions that have minor children, about 52% of adult males have minor children, and about 62% of female inmates have minor children who are now part of this institutionalized access to treatment by thinking that you have to go to prison to get it. You started to create those ripple effects in your communities that you now have to address and are being addressed poorly, if I might say, because of that level of incarceration.
One thing I would point to, if I can kind of take a stab at that, is alluding to what Bill had said. We have begun a process of recognizing that there are gaps, recognizing that there are challenges. And one of the things that kind of marveled me was the very first, if you don't know about JMI, we're largely considered a very conservative research think tank. The very first project I ever worked on coming to JMI 5 years ago was partnering with the ACLU, Human Rights Watch, and the Southern Poverty Law Center, examining juvenile justice policies and we all came to an agreement on the policy goals in mind. So while I would probably kind of agree with the premise of where you're coming from, I would also make the case that you've got 5 folks over here who are all saying there are definitely things that we can be doing. We have begun hard conversations over the last several years, and there are definitely going to be things that we disagree on. And in fact, I heard, something that everybody said here over the course of the last hour and 20 minutes, I disagreed with. So you're going to get that in the context of a number of kind of well-intentioned people. So I would push back a little bit on the fact that we're not kind of doing things that we should. We're beginning a very long and very challenging process that probably was put in place anywhere from 25 to 30 years ago that is presenting challenges. Yes, sir.
So one of the main problems in my mind is the mandatory minimum sentence. Is certainly a big problem in the federal system, which I'm more familiar with. But equal problem here because it rips the discretion, any discretion from the judge, or basically any discretion from the judge. So, Senator, you indicated that you have some issues yourself with the mandatory minimum. What is the legislature doing, and are there others like you in the legislature that are concerned about this? Because we have a lot of people locked up, non-violent offenders, particularly in drug cases, under these mandatory minimum schemes that seems pointless.
Sure. Well, I think in my opening I referenced 2 modest bills that I sponsored that I used to illustrate. I'm sorry?
Something more organized, except that it's different than sort of this ad hoc approach that you described.
Right. The nature of the legislative process is such that finding middle ground is how the system is designed. That our founding fathers set it up that way, and we in the 50 states inherited their model. And so I think you're going to see, whether you use the term ad hoc or whatever it is, you will see that just a wholesale dismantling of 1020 life, 85% and minimum mandatories is not something that is practical, period. Full stop. Now, the idea of dealing with nonviolent as a cohort of the larger policies is something that I think is I'm very interested in doing. I would love to do and do more than the nibbling that we've talked about. But I think when it comes to violent crime and gun crime, that then you are talking, about doing things like taking ag assault out, but maintaining the general model going forward.
All right, we might have one, if it's a quick question, maybe two, but I saw this one, and this one, and oh, wait, I promise you. I apologize. No, I'm sorry. I promised back there, and I've been going left the whole time. Please.
I had a question just more for the senator. If you guys have contemplated changing how we do petty thefts in the sense of right now we often have people come in with felony petty thefts because they have priors, and they're coming in for food, honey buns, Pepsis, things like that. So has there been any?
It's like the Oscars. The music's going to start. I love your question, though, so keep going.
Has there been any consideration in making it where if it's a food or maybe a necessity,
Yay! Hi!
that we keep those only in the misdemeanor realm and we prevent those from being able to come up as felonies so we can actually use the felony petty theft for the purpose that it was created, which is to punish people for committing offenses that are more things like stealing a stereo when it's not a necessity.
Well, the idea of right now, the difference between petty theft and grand theft is a $300 threshold. And the idea of raising that $300 was actually a bill that proceeded all the way to the floor. I think it might have passed out of the Senate, or maybe that was the vehicle that we used for the things I described earlier. I think it might have been the vehicle we used for the things I described earlier. And that was not ultimately a part of it. But the answer is absolutely yes. I think that you'll see a serious discussion about raising the threshold. Now, if you're talking about the deal where if you have 4 petty thefts, then it becomes a felony or whatever it is. I mean, if it's the third time someone's stealing something and they're saying they're, hungry, I mean, I think a multiple offender situation is there would be less inclination to do that.
Well, I guess just sorry, a very short follow-up.
No,
also,
of course.
We're talking about putting people in prison for these nonviolent offenses. For someone who stole cortisone cream because they couldn't afford it, and now we're going off to prison for 14, 15 months, or sometimes even 5-year sentence, depending on their priors. It seems an awful waste of resources to be putting that person away in a prison cell, in prison, and then also have all the issues that come out, considering the circumstances could be dealt in a misdemeanor setting for a necessity.
Sure, and I can only speak for myself. I can't speak for my colleagues. There is a very big appetite to deal with raising the threshold. When you're talking about repeat offenses, that becomes a more difficult road to hoe from a policy standpoint to make major changes on that front. I think Bill described the situation earlier about the judge who's sitting and someone is in front of them for the 4th time for the same thing. If there's evidence of mental or substance abuse involved, then that could potentially go to one of those specialty courts. Okay, but if you're talking about somebody who's just stealing stuff over and over again, then there's going to be an increase in penalty over time.
Hank passed me a note, said we can take a few more questions because we've got a big gap. So I will be able to get to folks, but if you need to take a break, go for it. But we've got here, and then there were a couple of others over in this way. So yes, sir.
Senator Radley, I agree with about the situation where you have someone who has lost a daughter,
right,
and the idea that they should, life means life. Okay, trying to explain that. But there are a lot of people serving life means life sentences where no homicide occurred, no death occurred, with robbery, with burglary, with some of those that are considered violent offenses, as opposed to just those that are nonviolent. And I'll just ask that when you start thinking about these, start considering those cases also that are non-homicide, where you don't have someone losing a family member. That's all.
I think that is the type of detailed discussion that I know and all of us who are involved in these issues are welcome to have. I mean, that's when you craft a statute and you're saying what are the circumstances by which there would be eligibility for X consideration.
For not taking a life.
And I think please don't interpret anything I've said as precluding a consideration of something like that. I was more giving a general statement of sentiment to hopefully inform people's.
That's very hard to overcome when you've got someone that's lost a daughter.
Yes.
A family member to explain to them.
Right, and I'm right. And I think my purpose on this panel is sort of give you the group a flavor of what the legislature is thinking, and they are often broad strokes, but that detail work is all important, and that's the type of detail that we would all be open to considering.
Over here.
So I am interested, and I think from the state attorney and Senator Radley, the perspective on specialty courts, the concern I have is they are for first offenders. We have chronically mentally ill people who've been addicted to substances for years and years, so have prior convictions, who are excluded from those services. So we're spending lots of money on low-risk first offenders, and those folks in the middle, because of their prior record, before those kinds of specialty courts were available, are disqualified. Do we see a place where we can address those nonviolent offenders who suffer from those problems?
Yeah, the answer is yes, and I will tell you that we have a specific appropriation that is recurring in the budget for courts that only deal with people who otherwise would go to prison. And you don't qualify to otherwise go for prison unless you have priors. So it might be in your particular jurisdiction, you have rules that are set up amongst the judges, state attorneys, and PDs that we're only dealing with first-time offenders. I'm telling you that is not a legislative mandate. And, we can't have it both. This is the tension. The tension is always, well, my jurisdiction's doing this wrong, so pass a law in Tallahassee to fix that. Well, now it's a one-size-fits-all,
Well, I would just respond, and maybe this is something that
Right.
Cervone can talk about, is the state attorneys are the gatekeepers more often than not in our specialty courts. And that is where the rules end up being sort of drafted by the prosecutors. And so, how do we address that?
I think that if jurisdictions are not including in their mental health court, drug courts, and specialty courts, individuals who have had prior records, they are not doing it right in the minds of most legislators.
I'd like to give Bill a chance.
I can tell you only that in my jurisdiction, it is not an absolute. There are very few absolutes. We have an ad hoc process that we can look at and reevaluate individuals. I can also tell you that there is a firm necessity to have some rules to follow for admission to this and any other program. Otherwise, we simply can never get anything done. Give me an inch, they ask for a mile.
All right, and I think we're going to close it off with this question here.
What we haven't talked about is the impact of poverty on the criminal justice system. When we talk about the criminal justice system being a 1.6% of the total budget, we ignore the fact that the way you escape poverty generally is with education. If we don't have early learning funded, if we don't have the ability for people to get a good education and to get a job, they're going to end up in prison. So when the legislators who say they're not interested in criminal justice issue, when you tell them, look, if we address these education issues, social service issues, mental health and substance abuse in the community, we're going to save money in the long run, regardless of whether it's criminal justice, because it's what should be done. We just keep ignoring the weirdly big elephant in the room. We do 70 to 85% of the criminal docket in the Sixth Circuit, and it's all poverty. And if you can't escape poverty, you're going to not escape prison.
Well, the good news is our unemployment rate in Florida is below the national average, and our economy under many judgments is doing very well. So those are good debates to have in
And in fairness, this was a sentencing panel, so I want to, we try to stay in our lane for this one. So with that, I would like to thank a wonderful group of folks, and I would encourage you all to join me in thanking them very much. It is not easy for this to happen. So thank you very much to the folks at the Florida Bar.
Judge,
and I believe our reception starts at 5:30 right next door.